Hello everyone. Today we are here to discuss the Roads and Traffic Authority NSW versus Dederer 2007. We have chosen to represent the defendant side. RTA NSW also discussed the relevant findings of the Court of Appeal and High Court of Australia. At about midday on New Year's Eve 1998, a then 14 years old Philip Dederer dived off the Foster Tuncari Bridge and struck his head on sandbar, which left him paraplegic. Philip had earlier noticed a sign posted on a telegraph pole at the end of the bridge that showed a pictogram depicting no diving. Nevertheless, he decided to climb out onto a handrail and dive 8 or 9 meters from the rail and into the water below. Unfortunately for Philip, the tide was running out, leaving only 2 meters of water between the surface of the water and estuary bed, and he got stuck at the bottom of the channel with his head down. At the age of 19, Philip Dederer sued both the RTA and the Great Lakes Shire Council for negligence.
Judge Dunford in the Supreme Court found both the RTA and Council negligent. The sign erected by the Council in conjunction with the RTA constituted a prohibition and not a warning. On that basis, the court found that both the Council and RTA had breached their duty of care to Mr. Dederer for failing to erect warning signs. It also discovered the defendant RTA to have breached its duty of care by failing to make a necessary installation in the form of a handrail. As the RTA had overall control of the bridge, the greater access to funds from those connection with the bridge had created the danger in the first place and failed to modify the structure. When the no diving pictograph proved ineffective, His Honor apportionate 80% responsibility to the RTA and 20% to the Council. The risk of harm would not have been obvious to a reasonable person in his position. His Honor also found there were 25% contributory negligence on the part of the plaintiff.
The RTA and the Council both appealed against the trial judge's conclusion and decision of carelessness and apportionment. In the Court of Appeal, Judge Handley and Judge Tobias agreed that the Council exercised a substantial degree of in effect control over the bridge and assumed answerability for certain aspects of it. It was furthermore held that the possibility of severe spinal damage from the act was apparently a 14 years old person with the awareness of the area and the circumstances of such an act. Even without a drawing sign of driving prohibition, it should have been understandable to a reasonable 14 years old that such an act was unsafe and could lead to terrible injuries. The proof indicated that the RTA was aware of the fact that young citizens were diving off the bridge. Despite knowing the threat of serious injury posed to a young host of people who were frequented to the bridge, RTA took no measure to raise their level of care. A symbol prohibiting diving would have been more effective at the relaying the danger associated than the sign RTA had already erected. After weighing the importance of the threat and the greater probability that would occur, the expense, difficulty, and inconvenience to the RTA in taking the steps identified, the Court of Appeal upheld the trial judge's finding that the RTA had breached its duty of care to the plaintiff.
RTA's appeal was upheld by the majority of the High Court, with Clinton CJ and Kirby J dissenting. Justice Gummo, Callinan, and Hayden were of the opinion that RTA indeed owed an obligation to warn users of any potential danger associated with the use of their roads. In this case, it was not the roads or bridges that posed a risk to the life to Mr. Dederer, but the act of jumping into the shallow water below. And even though Mr. Dederer's decision to jump was out of RTA's hand, an expenditure by RTA worth $250,000 could have helped build a handrail and fence built for prevention of such acts and protection. However, Had RTA undertaken this expenditure, there was still no guarantee people's safety if they are bent on acting reckless. In cases like this, while duties of care may vary in nature and scope, it all rests on the exercise of reasonable care. RTA could not have controlled the level of water beneath the bridge, and neither could it have controlled how a reasonable person would act in the face of the warning sign.
The extent to which a risk is obvious depends not only the particulars of the case, but also how we interpret it. In this particular case, 3 High Court judges and 1 Court of Appeal judge had held one opinion, while the rest believed in other scenario. While some believed a sign was prevention enough, others believed more should have been done. It clearly shows how different judges can look at the same case and come up with different point of views.